and welcome to a newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape.
What happens when nobody is quite sure where the fence should be? Welcome to Unpacking the Case. This week, we're delving into a boundary dispute that made national headlines. On the face of it, the disagreement in Todd and Marsh concerned a relatively small piece of land. As is often the case with boundary disputes, the legal issues were anything but small. The High Court was asked to consider the effect of informal boundary agreements between neighbours. In this podcast, we revisit a line of cases stretching back more than 2 centuries. From an 18th century dispute that still influences modern property law to some of the most recent boundary decisions, we bring together many of the principles that continue to shape how ownership disputes are resolved today. So, could a conversation between neighbours really settle a boundary dispute? When will the courts uphold an informal agreement? And why do these cases continue to generate so much attention? Let's unpack the case. Hi, Richard.
Hello, Lizzie, and what have you been up to since we last talked?
We just got off a webinar just before lunch. We've had our lunch and now we're back together.
I haven't had mine.
Oh, well, you've missed a trick. It's getting on. It's nearly 2 o'clock.
Mm-hmm.
So we're here to talk about a new High Court decision from the 10th of July. It's one that made the national news. It's all about informal boundary agreements and general boundaries. And the case is called Todd and Marsh. So, do you want to kick things off by telling us a bit of the background on this one?
Yeah, well, I'll tell you the history because we've come across similar arguments in the not too distant past about whether informal boundary agreements can be binding on successors in title and the likes to the land. And do you remember we did 2 podcasts just over a year ago in June and July of last year, 2 cases close to one another. There's a Court of Appeal case called White and Alder and a case called Bishop and Jacques, which is up a tribunal decision. You remember those?
I do, and we can link them in the description of this episode if people want to go back and listen to them.
I mean, I'll just briefly sort of revisit both of them. I mean, there have been cases going back for many a year. One of the cases I mentioned within White and Alder was one from the American colonies before the War of Independence, Penn and Lord Baltimore in 1750. Do you remember that one? Settling the boundary between Pennsylvania and Maryland on the Mason-Dixon land, the Mason-Dixon line, but giving rise to the Dixie, the South. And so it goes back a long way. But there'd been a case called Neilson and Poole in 1969, a High Court decision, also one that conflicted with it called Gibson and New in 2021. And Neilson and Poole said you can distinguish, because if you're going to transfer land, if you've got an agreement to transfer land with a few exceptions that need not bother us, if it's a contract, it has to comply with Section 2 of the Law of Property Miscellaneous Provisions Act. It has to be in writing, contain all the express terms referred to in one document and be signed by or on behalf of the parties. But they said that, there's another possibility. You can either be transferring land, which will have to comply with the formalities, or you might just have agreement to decide where the boundary is, and that doesn't have to comply with the formalities. And Gibson and New sort of questioned it. Gibson and New was actually finally settled, I saw last been going on for 13 years. The case itself was 2021, but they finally settled the damages claim on last Friday, I think it was July the 31st. And it's amazing how some of these neighbour disputes last, so long and cost so much. But Gibson and New had said obiter that such agreements, wouldn't be binding on third-party purchasers. But White and Alder came along from Chelmsford in Essex. Court of Appeal case said they would be binding on third-party purchases, informal boundary agreements, and they wouldn't if it was a boundary agreement as opposed to just transferring an interest in land with a question mark over where the boundary is. Then it didn't have to comply with the formalities. And a case soon afterwards, Bishop and Jacques from Sussex, from Battle in East Sussex, had basically confirmed that, even though it was a large piece of land, in White and Alder, it was just there was a wall that was in dispute between Mr. and Mrs. White and Professor Alder and his wife. And unbeknown to both of them, then the predecessors had agreed this boundary agreement. Bishop and Jacques was a piece of land 4 metres by 30 metres long. And the latest sort of instalment is Todd and Marsh. Also took place in East Sussex, in Robertsbridge, which is only about 5 miles north of Battle, which makes you think. But very litigious area, obviously. The background to that was that originally the land comprised one large piece of land, but in 1970 there'd been a transfer of part of this land. It had been sort of split into 2 separate pieces, and one piece was Wyland Wood, and the other piece of land was, well, the case termed the marshland. What then happened is Mr. Baldwin purchased basically all this land and sort of basically merged them together again in 2016. But then in 2018, he sold Wyland Wood, which is a house with 2.7 acres of land or so, they thought, to Mr. Todd and his partner, Ms. Hodge. And Mr. Todd seems to have thought, he claims to have been told by the estate agents that there was a dog and deer proof fence. I don't know why dog and deer.
What do dogs and deers have in common? 4 legs. Do they both have tails?
They both like to go through fences. I don't know. But dog and deer proof. I know deer can jump a heck of a way, but Mr. Todd was quite keen on this because he had a couple of Labradors. So he thought this land was about half an acre of land. And Mr. Marsh purchased the neighbouring land, the marshland, in 2021. And based on where the land registry plans say the boundary should be, which was about 6.37 to 11.37 metres to one side, and the land registry plans seem to, basically said that there was a row of trees and an old wire fence, and that should be the boundary. And surveyors came along and said, based on the 1970 conveyance, that's the case, and so on. So he tore down the dog and deer-proof fence. I'm not sure what happened to the Labradors. And basically, the first time they got an injunction against them and basically went to court. And that's the background, a neighbour dispute that gets out of hand yet again.
And what happened when it went to the courts then?
Well, the county court and the high court said pretty much the same thing. I mean, one of the problems, which we talked about before, is the general boundaries rule, section 60 of the 2002 Land Registration Act, which used to be in the land registration rules before that. The land registry don't guarantee the boundary under the land registration rules. You can apply to the land registry to determine the boundary with exact accuracy. The person you're claiming against, what you want to determine, I should say, has to either agree or not say anything within 20 days, 20 working days, 4 weeks. So therefore, they basically argue you can't rely on where the plans say. Surveyors on both sides had said that the plans would say that the row of trees and the old wire fence and not the dog and deer-proof fence, like they're the boundary. And they also tried to argue that the previous owner, Mr. Baldwin, before he sold the neighbouring piece of land to Mr. Marsh in 2021, in 2019, they'd reached an agreement after storm damage that they would split the cost of protecting the dog and deer-proof fence and re-fencing and the likes. And they produced an email to that effect, we'll split the costs of this from Mr. Baldwin. And so they argued, based on what we talked about previously in Bishop and Jacques and the likes, then that's, even if the land registry is correct, then we've got a boundary agreement, an informal boundary agreement, which would be binding on Mr. Marsh when he bought in 2021.
So what was the decision?
Well, I say both the County Court and the High Court basically said this email from the predecessor wasn't sufficiently, showing consensus. He didn't really have any conscious, decision. He was just deciding who would pay for the fence to be repaired. And it wasn't a boundary agreement as to where the boundary was. He admitted himself that he was called and gave evidence, and he admitted himself that, when he'd sent this email, he was just trying to be neighbourly and settle, who should pay for this. And it wasn't meant to in any way determine the boundary. So that, and the fact that the land registry plans seem to have been rather accurate, although they were expressed to be identification plans only. The amount of land involved, which was half an acre, which was 8.5% of the whole of this 2.7 acre plot of land. You can't argue there's a boundary agreement. In those circumstances, it's got to be a decision by both parties that this is why we think the boundary is. And if it's obvious the boundary is elsewhere, or if it's not a real consensus, it's just being neighbourly, you can't rely on it. So a big limitation. Got to say, Bishop and Jacques was a big piece of land though itself, which was subject to this predecessor's informal boundary agreement. But there you go. I'm sure we haven't heard the last of it. But remember, you can't always rely on the land registry plans, even though they prevailed here.
An excellent tip to end on. Thank you very much, Richard.
I live by that maxim all my life.
Thanks very much, Richard.
Thanks, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.